Good afternoon. Welcome
Yeah.
to
Good
our
afternoon.
special session today of the Kansas Court of Appeals. I am Catherine Gardner, and I will be serving as our presiding judge. On my right is Judge Tom Hill, and thank you. On my right is Judge Tom Malone, and on my left is Judge Stephen Hill. One moment for technical difficulties. Let me ask counsel individually, can you hear me?
I can hear you.
Yes, Your Honor.
Can't hear him.
Yes, Your Honor.
I cannot hear you, counsel.
You can't hear any of us?
Okay. I will just call the case of 125258, William Lauren Corbett versus the City of Kensington, Kansas, and Cunningham Sandblasting and Painting Company, Inc. And would like your appearances, please.
May it please the court, Your Honor, Todd Powell appears for plaintiff William Lauren Corbett.
Thank you, counsel.
Alan Glendenning appears on behalf of the City of Kensington.
Thank you.
And Alan Path appears on behalf of the defendant Cunningham.
And are the defendants arguing, splitting your time today, the 15 minutes?
Yes, Your Honor.
Yes, Your Honor.
Very good. And how would you like to split your time?
Evenly.
Very good. Well, let's go ahead and begin. This is a 15-minute case. Appellant, would you like any time for rebuttal?
Yes, Your Honor, if I could reserve 3 minutes.
You may. Please proceed.
Thank you. Your Honors, this case presents 3 questions of law. Therefore, your standard of review is de novo. All 3 legal determinations from the District Court of Smith County that we're here on today are legal conclusions. They arise out of, I'm not going to go into depth in the facts because I think you have those facts in front of you, but this case arises out of a project contracted by the City of Kensington, Kansas. They contracted Cunningham Sandblasting and Painting to refurbish a water tower. The water tower sits immediately adjacent to the Corbett property, very close. So there's pictures in the record that I think demonstrate this. And during the project, sand and other debris and media came onto the Corbett project or Corbett property from the project. Mr. Corbett himself went out one morning, walked on an elevated garden bridge he has on his property. It had sand on it from the project. He fell, sustained injuries.
Mr. Powell?
Yes, Your Honor.
At that time, do we know how much sand was on the bridge?
There's descriptions of it in the record from various witnesses. One of the city employees returned from going to the property after he heard there'd been an accident, and he came back and said there was a lot of sand there. Both the plaintiff and his wife had described there being lots of sand on the bridge. Again, there are pictures in the record that show what, in my words, piles of sand on an adjoining garage or shed. So there was a substantial amount of sand, Your Honor.
Thank you.
The first legal conclusion of the district court that I want to address, Your Honors, is whether or not the court erred in ruling expert testimony is required to establish Cunningham's negligence. The judge found that Cunningham owed a duty of ordinary care, but then the judge held that there wasn't sufficient evidence of breach of duty. And that expert testimony was required to establish that because this was a water tower project. The subject matter was specialized knowledge and information outside of the ordinary knowledge of a jury. And Your Honor, we submit that that was error for the court to make that ruling. We submit that if the duty was ordinary care, the proof is the breach of duty is ordinary as well. And certainly the mechanism of injury in this case is not specialized. It's not complicated. It's Mr. Corbett falling and slipping on sand that was from the water tower project. That involves.
What is it? What is the breach of duty that's so obvious? What should they have done they didn't do, or what didn't they do they should have done?
Your Honor, we submit that they shouldn't have allowed sand to leave their property. and go on to the adjoining property. And in terms of what specific steps they should have taken, I'm going to talk about a case here in a second that has the very same issue in it. And the court in that case held that the breach was obvious. There was no need for expert testimony. We think that's very analogous. But I think just the presence of sand alone, it's not per se negligence. It's not strict liability. It's not re ipsa loquitur. But we think the presence of sand that caused the injury is enough for a jury to at least weigh it and see the pictures and hear the testimony and determine for themselves whether they think Cunningham was negligent or not. We think what Cunningham is doing is they're trying to convert this into a malpractice case and say, well, they're really saying this is water tower, repair malpractice. That's not what we're saying. What we're saying is they failed to take reasonable steps to keep sand and other debris from coming onto the Corbett property, knowing the close proximity of the property to the water tower, and therefore that presents a submissible case to the jury. The analogous case that I wanted to bring up, Your Honors, is I'm going to pronounce it Junke. There are two cases arising out of nursing homes, Junke and Tudor. Junke is, in each case, came to a different conclusion in terms of whether expert testimony is required. So that's the basis of our claim, that it's the mechanism of injury, not necessarily the subject matter or the project involved, that you have to look at to determine whether or not expert testimony is required, because both of those cases came from the same setting. Junke dealt with a patient being injured by a co-patient. The co-patient had, or the perpetrator, I guess, had violent tendencies that the nursing home was aware of. And the court came to the conclusion that treatment of the patient was so obviously lacking in reasonable care and had such serious consequences that lack of care would have been apparent to and within the common knowledge of mankind in general. That's a pretty strong quote and a broad quote. The treatment of patient was so obviously lacking in reasonable care. And that's our case against Cunningham. Their treatment of this scene was so obviously lacking in reasonable care because of the pictures of the sand, because of the descriptions of sand on the property. And we could ask those same questions that Your Honor asked me earlier, and that Cunningham has raised, and that the district court, frankly, below used in forming his decision. Those questions are, what should have Cunningham done differently? Should they have used a protective curtain? Should they have used different media? Should they have used a different method of sandblasting or brush blasting? We submit those same questions could be asked in Junke. What did the nursing home do or fail to do to keep the dangerous patient away from the victim? Should they have been held in different rooms? How should they have been separated? I mean, you could raise those questions about anything. But again, it's the mechanism of injury that I think we need to look at. The mechanism of injury was a fall from sand being on the bridge as a result of the project. The other case that I want to
Let me ask you a question about that, counsel.
Sure.
It seems to me that you're arguing that the city and the contractor simply had a duty to keep these foreign substances off of your client's property.
That's correct, Your Honor.
And they didn't, and so it's a breach of duty, and what follows are the damages. Is that right?
Well, I think what follows is an evaluation by the jury. What we're saying is this should have been allowed to go to the jury for it to perform its job in weighing the evidence. Again, we're not saying this is de facto negligence or strict liability, or one grain of sand results in liability. What we're saying is they should look at the pictures and hear the descriptions by the witnesses and determine if they think Cunningham was negligent. But we don't think there's anything specialized that requires expert testimony here. That's the plaintiff's assertion, Your Honor. The second case that arises out of a nursing home is the Tudor case. And Tudor dealt with a medical condition.
Counsel, you have very limited time. I'd suggest maybe you move on to the other two issues you wanted to address.
Okay, thank you, Your Honor. I do want to wrap up with Tudor because that dealt with a medical condition of a patient. So that's proof that arising out of the same setting, you can have one case dealing with requiring expert testimony and the other case not requiring expert testimony. We believe that there was error there by the court for not allowing this to go to the jury. With regard to the claims against the city, the independent contractor rule is what the district court had relied on and found that there were no exceptions, leaving the city liable, and that Cunningham would bear 100% of the liability because they were the independent contractor. We've briefed several exceptions that I think the court should have could have found any one of those applied. The three that I think are most applicable all revolve around the issue of foreseeability of harm or danger. And we're dealing with a 50,000 gallon water tank where work happens high in the air, immediately adjacent to the Corbett property. We think that there was enough foreseeable harm there. The city knew what was going to be done on the water tower. They knew there was going to be debris that was mentioned in the contract. I don't think they had to foresee the exact harm that happened. And that's something the court ruled that I think is another legal error, that the court basically said, well, there may have been harm here, but it wasn't the harm that was the most obvious or that the city contemplated, because the evidence shows that two city employees, when they heard about the fall, came to the same conclusion that, well, it was somebody falling off the water tower. Well, we submit that these exceptions don't revolve around having to find the most obvious harm that arises. The city, again, they knew the proximity of the location. They knew the work to be done. They knew what it was going to produce, sand and debris, and they knew that it had a tendency for harm. In terms of the immunity argument, this one I think is pretty straightforward. The liability is the rule and immunity is the exception, and the city in this case bears the burden of proving immunity. It's not available where a legal duty exists, and that's been a lot of briefing has happened on that. That's the Nero, Kansas State case, and as far as I know, that is still good law. There was an attempt to say the Gregg, Wichita State University case abrogated that statement, and it hasn't. In fact, Gregg said we specifically refuse to apply will not apply the discretionary immunity. That dealt with another type of immunity. So we don't believe immunity applies, and we believe at least one of the exceptions to the independent contractor rule apply, leaving the city liable simply because of their knowledge of what was going to happen with the project. One other thing that I want to mention that I think the district court did is that he took the justifications behind the general rule of liability only for the independent contractor, which is, they have more experience, they have the materials, they know how to do the project. And the judge took that information and said, well, none of these exceptions apply because the city didn't have the knowledge. Cunningham has all the experience in this. So basically the judge refused to apply exceptions based on the rationale that's behind the general rule, which I think is also a legal error. So your honors, I will stand down on that, and we ask the court to reverse all three of those legal determinations by the district court.
Thank you, Mr. Powell. Counsel for the defense, you may begin.
Which defendant would you like to hear first?
Whichever you decide, either's fine with me.
I think maybe we take it in the same order as the plaintiff. Alan, is that okay?
That's fine.
Okay. Boiled down to its essence, this personal injury claim is this: sand, blast media from our work got on the plaintiff's immediately adjoining property. So when he slips and falls on sand, we're liable to him, even though he's aware that the sand is there.
Did you have any kind of duty, sir? Did you have any kind of duty to keep that sand from blowing onto his property or falling onto his property?
The only duty we would have would be to comply with standard approved practice in the field, in the industry. And the fact of the matter is,
why is that? Why wouldn't you have a common law duty to protect adjacent property owners?
Well, I think you do, but the question is, what is the standard applied to determine whether there's a breach of that duty? For example, we used rollers. Those are more likely not to get paint on adjoining property. We actually used a lessened blast. In other words, this wasn't the most forceful blast we could have used, also because it's in a residential area. So it's not that there's not a duty, it's just a question of where's the proof that the duty was breached? Because the fact of the matter is, and this is typical of small town Kansas, they put these right in the middle of residential areas. There's no evidence in this record that it's even possible to do this work without sand
So
falling.
let
on the
me see
neighboring
if I
property.
understand your argument, sir. You're saying that compliance with some industry standards, what all of your companies perform, is equivalent to satisfying the common law standard to do no harm to your neighbors.
Well, I'm saying that expert testimony is required to show that there was a breach of that common law duty. Because an ordinary jury is not going to know what has to be done or what should not be done to comply with.
I don't understand that argument. An ordinary juror can say, there's sand and it's on this property and you caused it to come there. I mean, that's pretty simple, isn't it?
Yes, but what's lacking is any proof that it came there because we were negligent or careless. The fact is, there isn't any way to do this without sand. And in order to, let's look at it this way. In order to make this claim, the plaintiff would have to show that we shouldn't have sandblasted it at all, or that there was some way to have sandblasted and painted it with no sand dispersing. And in order to do that, you need an expert. Sometimes there's going to be things that even with the lack of negligence, there's still going to be some sand. And that's the situation you have here. Our point is you need an expert to talk about that. Have I answered your question?
Yes, sir.
Okay, very good. I want to talk a little bit about the semantics of this. I cite 2 cases in my reply. It says you can't get around the expert requirement if the knowledge is specialized. You can't get around that by calling it ordinary negligence instead of malpractice. In Midwest Iron, I wanted to mention that because that argument was just made. Also, the argument that the mechanism of injury is simple, but if you look at, for example, the Gaumer case which both parties cite, they don't look, the court didn't look in that case at mechanism of injury. The mechanism of injury was his arm got taken off by a hay baler. They looked at the claim of negligence, which was you sold this without the proper warnings. And they said, well, that's beyond ordinary knowledge, because most people they sell things, but they don't sell hay balers. So same logic was applied here by the trial court. Yes, people are experienced with painting, but they're certainly not experienced with how do you sandblast properly and safely sandblast a water tower and then paint it. They're not going to know what can and can't be done to restrict the media or to do that. And so the mechanism of injury is not really the point at all. And we still don't know, even on appeal, what exactly was it that is being claimed that Cunningham could have done to ensure that there was not any sand on this ornamental bridge. We still don't have an answer to that. And I would submit that this is far more complicated than Yankee. I mean, if you have somebody who's harming other patients and has that proclivity, well, obviously you have to separate that patient from other patients. But if you want to try to keep sandblast media to a minimum, how do you do that? Well, the juror isn't going to know that. And that's not obvious. That is technical and it is specialized. And I think the trial court got that exactly right. I might want to make sure I point out one thing while I have a chance, and that is this new argument that's raised in their reply about how since we voluntarily agreed to tarp the garage, therefore we agreed to maintain their property. First of all, it's not in the original appellate brief. So rule 6.05, and then there's the merit contractors, 41 Canap second 1010. Also, the McGee versus Chalfont case clearly says the scope of that would be limited to the scope of the undertaking. So the bridge where he fell is obviously not on the garage roof. And so that argument has nothing to do with the fall. I would also point out that it was tarped to his satisfaction on the 10th, and that's in the records, in our statement of facts, and he didn't fall till the 12th. So, and of course, the 2 lead samples that were found were not found on the garage roof either. So the scope doesn't reach to where he's claiming. So that would be in order to really do anything with that, he would have to say, here, I've broken out the damages just based on the garage roof not being tarped for a few days. But that hasn't been done. And so there's really no basis, for that argument. I also wanted to address
Counsel, you have about 1 minute.
All right. There was a new case cited in the reply as well. It was a chemical drift case. The delay case, I would just point out that there was testimony that right on the label, it said, no, don't apply this if there are winds over 15 miles an hour. And there was all kinds of evidence that there was wind over 15 miles an hour. But where's the corresponding evidence here, which says, don't do a sandblast like this, using this method. Don't do it this way. There's nothing. So all that does is just tend to back up the fact that, what you had in delay, you don't have here. And you still don't have any evidence of what the breach was. You have a duty, you have to have a breach of that duty. And a jury is just not going to know what should have been done or what shouldn't have been done without an expert weighing in on it. Thank you very much.
Thank you, counsel. You may proceed.
Thank you, Your Honor. From the city's perspective, this is a classic case for the application of the independent contractor doctrine, which would leave any issues that need to be resolved between Cunningham and the plaintiff. This is not one of the threads that runs through all the exceptions to the independent contractor doctrine really has to do with normal activities of a principal who's trying to slough them off or farm them out so that they can escape some liability that might attach to them, or it is so abnormally dangerous that there's just everybody's going to remain on the hook with liability. Neither of those situations is available in this case. This type of work is not the kind of work that a small city in Kansas has anybody on staff that knows anything about how to do it. We don't have the equipment. We don't know how it's done. We don't know what precautions may or may not need to be taken. And so we do what every other small city in this state and all surrounding states, for all we know, we hire the experts to come in and take care of the job for us on an as-needed basis, which tends to be a decade or more between the times those are needed. Plaintiff agrees that we are an independent contractor. The only question that we have an independent contractor position. The only issue is whether or not an exception applies, but the way the plaintiff argues the exceptions would make the exceptions the rule and the rule the exception.
Well, counsel, could you focus on the nuisance exception for a little bit, please, and help me understand what the record would say about the sand and whether it was a mere annoyance or in fact it could have been a public or private nuisance?
I would be happy to do that. And I think this also kind of applies back to the duty issue that was being discussed by Mr. Path, because the sand, in order to be a nuisance, there has to be a substantial and significant invasion. And generally, one of the things you can look at is continuity, duration, and frequency. And a one-off situation just isn't what rises to the level of a nuisance. And the case law that we've cited in our brief indicate that. An infrequent thing, even though it may be annoying, but it's infrequent, it doesn't even rise to the level of a nuisance. And this is a one-off situation. Okay, let's even assume that there's going to be sand that's going to have to fall on Mr. Corbett's property. As a result of the way this work is done, there's no way to prevent that. It's a temporary situation. Some sand falls on it under the contract. Cunningham was obligated to then, as soon as they got done with the work, which is a matter of days, they go clean it up. That doesn't rise to the level of a nuisance. It simply isn't significant enough, and it isn't substantial enough in its continuity, its frequency, or its duration. It's just one of those things that happens. When my neighbor re-roofs his house, I have to put up with listening to the banging of the hammers and the nail guns all day long. And if he's doing it with tar, I may have fumes wafting across my patio that will be annoying to me for a couple of 3 days. That's not an actionable invasion of my rights. It's one of those things that happens occasionally and rarely in a civilized society when we live together. And that's what we have here. This sand on the plaintiff's property was simply, it really wasn't any more significant sometimes than dust storms that occur in western Kansas. And you see dust drifts on my patio or on your patio or whatever. This just clearly does not rise to the level of a nuisance. Was there any other aspect of that you would like me to address, Your Honor?
No, thanks. You covered it.
Okay. I don't think any of the other exceptions are available either. Again, going back to that thread that goes through these cases, is we're looking for something where somebody farms something out that's really part of their normal duties. And that's what the Bleeda case and the National Mines case the plaintiff relies on all involved. They involved an ongoing regular business, and the normal course of that was just regularly ongoing on a continuous basis, creating a nuisance. And in one case, I believe the Bleeda case, the independent contractor had one client, and that was the principal, which is a classic case of a principal trying to farm something out to avoid the liability. That just isn't what we have in this case. Cunningham, there's no evidence that Cunningham had any knowledge of the risks that might be involved or had any idea what could or couldn't be done to prevent any of those risks, and relied upon Cunningham to do that. And I may have said Cunningham when I meant Kensington, because there's also a city in this state called Cunningham that we also represent. But Kensington had no knowledge of how this was going to be done or how it would play out. It's routinely done by Cunningham all around several states, thousands of times under similar circumstances. So there's clearly absolutely no negligence in how they picked Cunningham, because the plaintiff himself identified Cunningham as the expert in this field. And it clearly is. That's all the evidence there is in the record, is that they're the experts. They do this thousands of times in multiple states. And to say that the city was somehow negligent in selecting this company, who's the go-to company in this state and many others, there's simply no evidence in the record to support that. One of the most red herring arguments that's been made in this case is that somehow the fact that the workers could fall off of that tower while they're working, and that harm creates a duty to the neighbor to keep sand off of his bridge, is just a complete non sequitur. And I think the plaintiff's attorney very carefully characterized that as, well, you don't have to know the exact harm. That may be true, but you at least have to know who the subject of the harm is, or who's going to suffer the harm. To say that we knew somebody might fall off of the tower working up there means that now we owe whatever duty somebody can come up with to any neighbor is just a complete non sequitur. I'll finally just quickly address the immunity argument. When you focus on the immunity, if you do it like the plaintiff would like it done, once again, we are swallowing the rule with the exception. What you have to look at is whether is the specific conduct that's involved. What was it that we were supposed to have done? And in this case, plaintiff is saying, well, we should have given different notice, but there is no duty to give different notice. And certainly if there was any duty, it's discretionary as to how that notice is given. So we would fall under discretionary immunity. The other complaint is that the city didn't require more of Cunningham than it did in its contract. First of all, how they would even know what to require more of Cunningham, the expert that everyone agrees is the expert, is problematic. But in addition, it is clearly discretionary as to what they require in the contract. There's no mandatory guideline or duty. Simply talking about a general overall duty to not invade the rights of others, if that's the only duty you have to make to get past the immunity, then the immunity's gone, because either you have a general duty, which if that duty doesn't exist, there's never any liability, so there'd never be a reason for the immunity to attach, or that general liability first attaches. Then you look at immunity and you look at the specific conduct that's being complained about or omission, and you determine whether or not that specific conduct was discretionary. And if it is, then it falls within the discretionary immunity. I guess I said finally before, but finally, I would just point out that we also have a conditional cross appeal. If the court were to reverse the judgment in favor of the city, it would also need to reopen and remand the city's conditional cross claim against Cunningham. Beyond that, I will stand on the briefs or answer any questions that you may have.
Thank you, counsel. Mr. Powell, you have 3 minutes.
Thank you, Your Honor. I'm going to start backwards here. I want to address one of the last things Mr. Glendenning said about this concept of, I think the district court judge called it collateral negligence, that being up high on a tower may be inherently dangerous, and there may have been reason to worry about someone falling off the tower, but that's not what happened here. Actually, the restatement, it's section 427 in the restatement, and there's a comment that directly addresses this. This is the exception for when you hire an independent contractor to do something inherently dangerous. And by the way, an example mentioned in this is scaffolding, and that ties directly into what I'm about to read here. Likewise, use of a scaffold in painting the wall of a building above the sidewalk involves a recognizable risk that the scaffold, paint, brush, bucket, or painter himself may fall and injure someone passing below. So that's, I think, a pretty good reputation that you don't have to know exactly what's going to happen. You have to know there's reason to believe harm may arise out of this. And we believe scaffolding and painting a water tower is really pretty analogous here. So I wanted to start with that point. Let me back up a little bit and address a couple of the arguments Mr. Paff made. He's basically making, well, we didn't prove that they could do something to make sure there was no sand ever getting on the Corbett property. That's not the standard, and that's not our claim. The issue is whether they acted reasonably in the furtherance of what the district court judge found was an ordinary duty of care. Did they act reasonably in furtherance of that duty? And we submit a jury could look at the pictures, look at the evidence, and conclude that they did not. And there is no absolute rule like that. Mr. Paff also mentioned sand being on the bridge for 2 days. That's a comparative fault argument. There's a lot of argument in the brief wanting to apply the open and obvious rule that on its face only applies to a landowner failing to warn, or what duty a landowner has to warn a visitor about defects or dangerous conditions. Those circumstances don't apply here. This was the landowner being injured. So what they're doing is just disguising a comparative fault argument, because the open and obvious rule would be a complete bar to plaintiff's claims, whereas comparative fault would not be. So any issues about how long the sand existed or plaintiff's knowledge or anything like that is all comparative fault.
Well, let me ask this then. As far as your nuisance claim goes, don't you have to show that the city knew or should have known that the Cunningham's work was likely to create a nuisance?
That's correct, Judge, and we think there's evidence in the record to support that. And that was another point I was going to touch on. Mr. Glendinning talks about this being a one-off and it's not a substantial interference, it's not significant. Those are issues for a jury. These are all jury questions. But yes, Your Honor, we do have to establish knowledge of the city in order to apply this exception. But as we put in the brief, the contract talks about spent media and debris being cleaned up. There's a reference to compressed air nozzle blasting and spent media and debris. There was discussion of use of a protective curtain between Cunningham and the city. These things all impart notice, and again, at least create an issue for the jury to go to the jury for them to determine. This issue of, and it's been raised in the briefs as well, that, well, we identified the principal of Cunningham as an expert, so therefore we've acknowledged he's an expert, and we're stuck with his testimony. That we identified him before we took his deposition, and we didn't know what he was going to say, and our disclosures plainly says that. We stated what we anticipated his testimony to be. Unfortunately, he disavowed knowledge of most things, including disavowed when I showed him the picture of the sand, he wouldn't acknowledge that was from this project. So he basically said that whenever an engineer says a protective curtain is to be used, that's the standard, but he couldn't speculate beyond that. So we don't think that either creates a standard or makes us, having adopted Cunningham as an expert. I just have a quick second here to make sure I've addressed everything. Your Honors, I think I'll rest on that. Again, we would ask the court to reverse all three legal determinations and remand this case back to the district court. Thank you.
Counsel, we thank all of you for your arguments today. We'll take the case under advisement, and we will get you a written opinion when we can. Thank you. Court is in recess.
Thank you.
Thank you.